Hey guys, another question that I get is, are LOPs affected under this new law? Am I capped on what I can bill for an LOP? So I want to say you're not affected really by this new law, House Bill 837. When it comes to LOPs, let me explain. So originally, what was originally proposed, the original version of this House Bill 837 said that a jury would only hear the Medicare rate allowable. I think it was 150% of Medicare, something like that. The percentages keep changing. I don't know what kind of crack these legislators are smoking. In the first version, it was 150%, let's say. In the second version, it was 180, and they settled on 120% of Medicare. I don't know. These people are smoking crack, but it's like that Washington, D.C. mayor. They're all on crack. But the original version was that the jury would only hear, 150% of Medicare, okay? That has been watered down and changed so that now the jury will hear 120% of the Medicare rate, okay, or 170% of the Medicaid rate if it's not covered by Medicare. If the patient has health insurance, a jury would hear what their health insurance would reimburse, even if they don't use health insurance, okay? But the jury will also hear, and this is the important part, will also hear what the billed amount was from that doctor. So let's just say, for instance, we have a surgery bill. The surgery costs, the bill is $100,000, let's say, okay? And I'm exaggerating the amounts for purposes of this video. So let's say it's a $100,000 bill from the surgeon, and let's say Medicare would pay $1,000. So a jury under the original version would only hear that the bill is $1,000. They wouldn't hear that the injured person owes $100,000 to that doctor. They would only hear it was $1,000. Now, under the new version of the law, the final version of the law, the jury will hear, hey man, it's a $100,000 bill with this doctor, but Medicare would pay, 120% of Medicare would pay $1,000 for that same surgery. Oh, by the way, that doctor doesn't take Medicare because Medicare rates are horrible. Oh, by the way, that patient's only 40 years old. They would have to wait until they're 65 or whatever the age is nowadays to get Medicare benefits. They would hear all sorts of information about why Medicare sucks, why the patient isn't eligible for Medicare. So it's okay. What ended up being finally passed with LOPs, like I said, 120% of Medicare, 1.2 times Medicare, however you want to phrase it, what they would pay. Now, this is important for chiropractors. We're talking about surgeons, but this is important for chiropractors. We know that Medicare only pays for the adjustment, okay? So it doesn't take a lot for a defense lawyer to say, hey, this bill, they would only get paid $500. But think about this. Let's say the person's not Medicare eligible right now, and they're not going to be Medicare eligible for 10 years. You would still say, hey, listen, the care that I gave this patient is what they needed. It's what they deserved. If it was my family member, this is what I would do for them. And yeah, Medicare rates are unreasonable. They just pay for the adjustment. But this person was in an accident. They needed extensive care, extensive therapy. And so keep that in mind, because we know that, Medicare only pays for the adjustment. A lot of times the adjustment is the same amount as a copay. So you end up keeping the copay and that's it. So, a lot of times, not always. So you could have a $15,000 bill when you factor in the exam, the x-rays, the adjustments, and all the therapies you do, but Medicare would only allow $500. So there's a way to explain it to the jury under the final version. The original version, it lied to the jury. It said, this is what is allowed. That's it. That's all the jury would hear. So fortunately, there were some groups in Tallahassee that advocated for this, and the jury will now hear both stories, what Medicare rates are, 1.2 times Medicare rates. If it's not reimbursable under Medicare, they'll hear the, 170% of Medicaid. They'll hear what the doctor billed, and they'll also hear, if the patient had health insurance, what health insurance would pay for those services. Health insurance, a big reason people don't use health insurance in an auto accident is they got a $10,000 deductible. We just saw there was Cigna or Aetna has some type of software. Everybody's bragging about artificial intelligence, and now they're using it to deny claims, health insurance claims. You can Google this. It was Cigna or Aetna's denying multiple claims for necessary procedures. The patient and their doctor think the surgery is necessary, but the health insurance company saying, oh, you missed a diagnosis code. You didn't talk about, whether this was done or that was done. So they just straight deny it. They have a peer review doctor in another state sign the bill, sign the letter saying it's not necessary. And that's all from software, artificial intelligence, et cetera. So there's ways to explain, hey, even though there's health insurance, patient has a high deductible, health insurance doesn't want to pay for this, blah, 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 blah. At least the jury will be educated properly about all the situations, not just the one-sided story of what Medicare would pay. So that's the end of that. Thanks.